Right, good afternoon again. We're just approaching 2 p.m., so it's time to resume the inquiry, assuming everyone's present. Thank you. It seems like everyone is. So, just housekeeping matters. I did mention very briefly before we adjourned for lunch that I had received the appellant's closings. I hadn't at that time had a chance to review the email. I've just noted that the email had been received. I have a chance now to review the document. Thank you, Mr. Banner, for sending that through. Just to confirm that the parties are happy for me to accept it as inquiry document 17.
Yes, thank you, sir.
Thank you. Noted. Mr. Green, I hope your voice holds up. Can you confirm?
Yes, sir. Thank you. Yes.
Thank you. I can't recall whether you were present before the break. Do you know about the timings and so on, that we just need to continue the condition session before we get into closings, and we might
Yes,
have a very brief break to allow us to take stock before we move into closings.
Yes, sir.
Thank you. Any other procedural matters, Mr. Banner, Mr. Green, before we resume, or any other matters arising?
No, thank you. No, thank you, sir.
Parties?
No, sir.
Thank you. Well, in that case, we'll resume the discussion. I think we were approaching the final two conditions, so I think it was condition 20 we were up to, unless anyone wishes to correct me. So condition 20, just for certainty, relates to a lighting design strategy for biodiversity. I think we touched upon this in evidence previously, and obviously I'll take any comments that are received in evidence previously and as part of questioning of witnesses. In terms of the condition itself, the changes relating to aquaria of my own are very similar to we discussed in previous conditions, just in terms of it being first use, rather than any changes to the actual detail of that condition that was suggested. I'm happy to reflect on that condition, unless there's any and the wording changes that have been made, unless there's any specific comments that anyone has in terms of lighting. Obviously, I do know the comments that have been received on lighting already in the inquiry. Councillor Powell?
So it's not specifically about lighting, but I just reflected on the prior to first use during the break.
You okay?
Wondering, I mean, obviously burials could take place today. There is permission for that today. So in terms of a woodland burial, it can be used today. And I don't believe anyone could stop that from happening. So perhaps there is a clarification needed around that, sir. And I just wanted to bring that to your attention.
First use of the building?
Potentially, yes, sir.
Yeah,
yes.
I looked at that. I just looked at that myself as you mentioned it, and I thought that's something that, in terms of my minor clarifications, I could do so. But obviously, I will welcome comments as it's been raised, firstly from the council and then from the appellant. Thank you, Councillor Paul. Mr. Collett first, please.
Thank you, sir. I have to say, I'd also reflected on that after our morning session. I'm happy to leave it to your discretion, sir. It would seem suitable to make, prior to first use of the building or similar wording. I'm happy to leave it to you.
Yes, and it goes for any other example of any other example of other conditions. If I were to reflect on that, it's likely to be a consistent approach that I'd take. And again, it's something that could be updated by next Friday if it was something that was considered worthwhile in submissions from the council and the appellant. Mr. Steele?
Yes, that sounds a reasonable approach.
Thank you. Councillor Powell, you still got your hand up? Is there anything to add, or is it just a legacy?
Sorry, just one other point. I mean, this only talks about external lighting. Obviously, without the building being there, there is no source of lighting within the building. Obviously, that won't be particularly relevant in the summer months between 10 and 4, but obviously in the evening, there will be light that would be spilling out of the building at 4 o'clock because, you know, at certain times of the year, it will be dark. I'm just wondering if you could reflect on that issue, given that at the moment there would be no light there on site.
Thank you, Councillor Powell. I know that reflects evidence that you'd already mentioned in day 4, so I do that. I have that in mind. But just for certainty, any final comments on that from the council?
No, so I'm happy for you to reflect on that. It's not something conditions would normally cover and control internal lighting, but if you think that's necessary, then we wouldn't have any objections to it.
Mr. Steele?
Yes, nothing to add up on that. Thank you.
We don't have any remaining hands, so in that case, intention is to move on to the final condition listed, and that's condition 21. So condition 21 relates to the landscape and ecological management plan. And basically the comments that I had, it was really a query around the aims and objectives of management set out to do biodiversity net gain in Part A. The condition as written and proposed in the Statement of Common Ground Appendix refers specifically to the biodiversity net gain assessment in the ecological impact assessment, and that's the one dated the 12th of August 2024. But the question that I had was that seemingly relates to the proposed amended scheme submitted as part of the appeal, and that similarly to condition 1, whether there was an alternative scenario where the references to the document there would have to be altered to reflect the documents that were relevant to the plan submitted as part of the application and determined by the council. The response that we received is yes, that's correct. So my suggestion really is whether it is as part of any submissions by next Friday in terms of revised conditions that the council and or the appellant reflect on whether I need an either or option on that particular condition in a similar manner to condition 1, just for the avoidance of doubt in terms of how that condition should read. The condition for the landscape and ecological management plan is a fairly standard wording otherwise. So it was something that I didn't have a great amount of wording on other than to reflect on comments that I'd otherwise heard in evidence regarding ecology and in questions to witnesses. But before we move on from the whole conditions list, now's the opportunity to either raise any comments on this or any outstanding comments on reflection on the conditions list as a whole before we move to IQ 13. Councillor Powell?
Yes, I just wanted to reflect on the views of the Highway Authority as the expert essentially on the council side on how highway issues, in the fact that the council are still requesting that condition 3 of their original list, which is the provision of the walking and cycling route, is provided on the basis of the fact that they consider it to be a required mitigation. I understand that that is not the position of Waverley Borough Council, and it's not the position of the appellant, sorry. But I would ask that you consider the highways representation in your final analysis of the conditions that apply.
Thank you, Councillor Powell. It is my intention. Obviously, I've heard that matter in evidence earlier in the inquiry. Obviously, I don't have a proposed condition of that nature before me for discussion. So it would be a matter if I did consider it to be necessary. To have a look at the wording of the condition provided by the Highways Authority, and if it needed to be reworded in some form, I would have to consult the parties to deal with that in any written evidence. But I can take the views of Mr. Collett and Mr. Steele on that point as well, if there's anything further to pick up. But I do know the respective positions of the council and the appellant at this point, so it's just to clarify whether they're happy with me taking that response away and considering that condition and whether it should be imposed, and giving the opportunity for written comments if we were to deviate from it, were it necessary. Mr. Collett?
Yeah, happy for you to reflect on it. So I think you understand the council's position in terms of that condition. Would it be helpful to you if, when the appellant and the council look at the conditions list for next Friday, that we add that in, but obviously it will be disputed is being by both parties.
It may be helpful. It may be helpful to me for a ready review by the council, and the council maybe rather than the appellant.
Yeah.
To search through the consultation representations, etc., for any conditions that were not taken forward as suggested, just for certainty, as a list to say conditions not proposed, including any potential reasoning why that might clarify why they weren't taken forward. I am wary of introducing too much new evidence, so it may be the case that you just omit the reasoning and you just include the list of conditions not taken forward. So I have them before me and I can reflect upon them. And then if any further actions needed after next Friday with respect to those conditions, obviously in the scenario were the appeal to be allowed and planning permission to be granted and subject to those conditions being necessary, then given a written opportunity to the parties to on those conditions if they were to differ, reflecting on the fact that both parties at this present time don't intend to impose them but are aware of their existence. Mr. Steele?
Yes, happy with that approach.
Thank you. Just to confirm, once the inquiry is closed today, I will confirm that action to my case officer. So the case officer will be aware that we're awaiting that by the deadline. So we'll have a note on the file of that particular action. So I'll reconfirm it, but we'll make sure before we're closing. But it will be 5 p.m. Next Friday. Thank you. I don't have anything further on the list of conditions, and obviously that would be a helpful action to me. I thank everyone for the points that are raised on this particular condition list. Mr. Ban, I've noted your cameras come on. Then was there something you wanted to say?
No. Just think we got to the stage of the inquiry where we may be breaking for closing, so that's the only reason my camera's on.
We've still got IQ 13 left to go through, so we'll move on to that first. I think the one thing that I did say about IQ 13 is that I'd allow Mr. Steele to lead it to kind of explain the rationale for the approach taken in IQ 13. I have got a copy alongside that of CD 9.1. So if there's any reference to any other conditions or particular wording of conditions, we can go to that. So it might be helpful for those who are participating to just take a moment and have 9.1 before them as well, in case the discussion strays beyond that list and IQ 13. Can the participants, particularly interested parties, confirm whether they received IQ 13? They have a copy available to them.
We do, sir. Thank you.
Thank you. Okay, Mr. Steele, I'll let you just quickly run through your suggestions and the rationale for that. Obviously, we are focusing on and this is a general comment to all participants, we are focusing on the wording of the condition and the purpose of it. So there isn't any real need to return to evidence that I've already heard on days 1 to 4, because I've got that in mind. And the reason for asking for this document was to understand the interaction between the two permissions. So we don't really need to go back to that interaction too much unless it relates specifically to a deficiency in the wording or that's suggested, or a suggested addition to address an issue that's apparent between the two that isn't picked up in this wording. So I'll allow Mr. Steele to kind of introduce each condition in turn. I don't have a great amount. I'm more listening to the rationale for it rather than having my own questions at this point. But then I will invite other parties to comment on what they've heard, and then I'll allow Mr. Steele the final comment again. Okay, Mr. Steele.
Thank you, sir. So in my evidence the other day, I referred to a number of compliance conditions from WA/2010/0166 relating to the burial use, which I consider could be reasonably applied to the appeal proposal in the event permission is granted. in order to add clarity. To be clear, though, the appellant does not oppose these being applied, but would not accept the appeal should fail without them. So in that context, I have listed in IQ 13 4 conditions, and I've transposed the original wording of those 4 conditions and then provided suggested wording for clarity purposes, but in effect they're achieving the same outcome. So that so the first condition is condition 8, and that relates to the original wording, which is within the area proposed for woodland burials, no gravestones or monuments shall be erected. Within the cemetery, no gravestones or monuments shall exceed 1 metre in height without the prior approval in writing of the local planning authority. So the suggested condition, which also includes a red mark made by the council's witness, states no gravestones or monuments shall be erected on the site, brackets, for the avoidance of doubt, plaques, pavers or other ground level grave markers are permitted.
Just for certainty, you have any objections to the ground level element?
Not in principle, sir. It's just whether or not that's precise enough just to avoid any ambiguity in the future in terms of, you know, the actual depth of a paver or a plaque relative to the ground. So clearly this is a sensitive proposal, and we're trying to get clarity from these conditions, so the appellant can proceed accordingly. Thank you.
Thank you. The only other question I'd have is, yes, the original condition seemed to subdivide it into 2. So it was a simpler one that said no gravestones or monuments shall be erected for the woodland burial, and then it dealt with the cemetery, no gravestones or monuments. It allowed something up to 1 metre in height. Yeah, I think, yes, the reflection on the ground level and how that's dealt with. Yeah, the other grave markers, it's how you make that more precise, I think. I mean, it may just need some reflection a little bit on that particular point. So I think in terms of the submissions to be made by next Friday, these potential wording of conditions, that might be a 3rd category effectively. Mm-hmm. So you've got a list of suggested conditions, you've got a without prejudice conditions that may be potentially included if required to ensure continuity and addressing the interaction with planning permission WA 2010-0166, and then obviously the conditions suggested by others that have not been taken forward. So that's the 3 categories, just for certainty. Councillor Powell, got your hand up?
Yes, sir. I just wanted to say that I think the wording of condition 8 in WA 2010-0166 is very definitive. No means no. That means not at all, none whatsoever. And that was the original intent, as I understand it, of that condition. And it is the way that Woodland Burial Site, which is referred to in my representation, manages the situation. They have no gravestones or monuments. So I would just like you to reflect on the fact that no is in fact the most definitive statement. As soon as you allow something, how high it is, how big it is, how intrusive it is on the landscape is much more difficult to define. And you will note that in none of the pictures that have been presented by the appellant in any of the documents, is there anything shown, which is obviously very different to the situation on the ground at Brookwood, as you will have seen from my representation. So I would just say that the community is very supportive of the word no. Thank you, sir.
Thank you, Councillor Powell. Obviously, obviously reflecting on your comments and without prejudice to the consideration of your comments, and just focusing on in the event that I found that there were no harm in terms of plaques or pavers, for example. The other ground level grave markers does seem, as Mr. Steele suggested, it becomes quite ambiguous. I wonder whether there does need to be more certainty, even if I were to consider there would no harm for things like plaques and pavers to, for example, refer to planting as the alternative there, with it being a woodland effectively. Mr. Tilbury?
Well, I was just going to suggest, sir, with that in mind and the problem of ambiguity, and I agree that all the words suggested allow different interpretations, that it might be a situation where just leaving it to the prior approval of the local authority to determine whether something's acceptable or not might be a way of dealing with the condition itself, rather than trying to come up with detailed wording to do with two-dimensional, three-dimensional objects, which is always going to be tricky.
Thank you. I think I agree that it's difficult to be absolutely precise on other grave markers, and that's why my thinking, and obviously without prejudice to just looking at the word and the condition itself in terms of its precision, rather than whether it's suitable to impose or not, would be to be specific on what those other grave markers would be, or the alternative that you've offered, and to my mind, the other alternative, with it being a woodland planting area, would be some form of planting would be the other form of grave marker. But unless, obviously, that's without prejudice to any comments that Mr. Steele may have as well. Mr. Collett?
Thank you, sir. I just thought I would clarify, the reference to adding in the ground level, and that was obviously in response to the appellant's proposed amended wording, and we reflected on the reason for condition 8 about character and appearance, and it was to make it, we were hoping, clearer about actually not having any grave markers at height. Taking on board, though, Councillor Powell's no means no comment, we can reflect upon it for the notes by the end of next week. And the wording of that. I think, though, I wouldn't look to necessarily impose a situation where if every grave marker was, a marker was required for each grave, requiring a separate application for each could become.
Yes, it does seem to me it could become quite onerous if exactly. it would have to be a approval of a scheme of the types of marker that will be acceptable, rather than a plot by plot kind of approval. That does seem rather onerous. Mr. Steele?
Thank you, sir. Yeah, I think it's just applying certainty to the issue. I think I mentioned it before in a different condition as well, is to, ideally on behalf of my client, I would like to limit pre-commencement conditions or prior to use conditions based on such detail, because of timescales and what that may entail for the delivery of the project. So it would be the appellant's preference that it's specified in the condition what they're permitted to do. As I mentioned in my evidence at the inquiry, that the wording of condition 8 is pretty precise. It says no gravestones or monuments, and the change we've suggested is to confirm that, essentially. There won't be any gravestones or monuments on the site. It would be other plaques or pavers or grave markers. So that's what we're attempting to do. And that's
I understand. I just think before next Friday it might be worth a discussion with the council and other parties if necessary, to kind of understand how the reference to grave markers can be more precise, because there is a potential for ambiguity around there, around that particular position, and there could be potential creep. For example, what's a gravestone or monument compared to a grave mark? What's the difference, the material difference? I think there needs to be some provision if there's reference to forms to grave markers in there to provide a bit more certainty. I do understand the point that you're making in terms of ground level. Well, again, that there is a difficulty potentially there, because some form of marker, to what extent is something no longer ground level in terms of slight raising? Does that become no longer ground level? So, like, even for example, paving could be argued that there might be a slight difference to the level. It might protrude slightly above the ground, albeit very, very, very small in dimension. There is a need for some precision there, I think, if there is that form of clarification, obviously without prejudice to whether it's imposed or not, in terms of the suggestion that comes back to me next Friday. Councillor Powell?
Just one other point I would suggest you consider is any form of hard standing, whether that be paving or anything else, will of course affect the area available for absorption, will affect the flooding calculations. So whatever decision you make needs to take that into account as well.
Noted, and obviously I'll consider that in light of any other conditions and how that potentially affects it if they were to be imposed.
Thank you, sir.
Thank you. Anything further, Mr. Steele, or happy to move on to condition 9?
No, nothing more from me, sir.
Okay, if you want to move on to condition 9 then.
So condition 9 says, before any development commencement, its details shall be submitted to and approved in writing by the local planning authority of the depth of the proposed burials. The burials shall be carried out in direct accordance with the agreed details. Now that condition has been discharged, and there's a record of that in our application documents, which so it's really small.
I think you've
I think CD Ref 2.1. Yeah.
CD 2.1, yeah.
So in there's a discharge condition confirmation, which essentially states these details, which I've then transplanted into a suggested condition. Burials will take place between 1 metre and 6.5 metres below ground level. Ground level is defined as any ground adjoining the grave, unless otherwise agreed in writing by the local planning authority. So to be clear, they're not measurements proposed by the appellant. That's just respecting what's being discharged by condition.
Thank you. Noted. Any comments from the council?
No, sir. I accept what Mr. Steele has said. Yeah, and we've got no objection to that suggested condition wording.
Councillor Powell?
Yeah, I completely agree that that's the condition and how it was discharged. My only concern is 6.5 metres is below the groundwater. There is groundwater at that level, and I don't think it was. Yeah, I'm just making that point. But I agree that's how it was discharged. Whether it was a good idea or a bad one, that is how it was discharged.
Thank you. Noted. Anything further to add, Mr. Steele, or happy to move on to condition 11?
Yeah, just to note that's obviously a criteria, and the graves can be buried within that accordingly. Yeah, but happy to move on, sir.
Okay, if you want to proceed to condition 11 of the 2010 permission, please.
Yes, so condition 11 refers to no digging or preparation for burials shall take place outside the hours of 8 AM to 6 PM Monday to Friday and 8 AM to 1 PM Saturday. No digging or preparation for burials shall take place on any Sunday or bank holiday unless in association with an emergency or with prior written approval of the local planning authority. So the suggested condition follows the same wording, but has deleted the term preparation for burials to avoid any conflict or confusion with what we've been discussing about how the building will operate and preparation for funerals in that respect. So yeah, we've removed that wording. So.
And in that context, my assumption is that it's just making clear that distinction between the digging element now and the fact that the building probably incorporates some elements of preparation for burial that probably weren't foreseen as part of the original application, because it reasonably couldn't have known that a development would have come forward in that form.
That's right, and also that to confirm that these hours for digging the plots would work for the appellant, irrespective of the hours of doing this. That makes sense. Thank you, sir.
Thank you, Mr. Seal. Anything from the council before I go to you, Councillor Powell?
No, thank you, sir. Council's happy with the suggested wording.
Councillor Powell?
Yeah, I guess my concern is that we've ended up with no condition at this point around the use of the building for the preparation of the bodies for burial. So we've taken it out of here, and I completely understand why we're taking it out of this condition, and I completely support that. But I think it does raise again the need for some kind of condition to cover that use, because that use is only associated with the building. You know, it's not something that would have happened without the building if you are minded to allow the appeal. So I don't want to end up with a gap, I guess, is my concern. And I guess my other concern is, you know, the lighting effects of that kind of preparation. If you are digging in the dark, then clearly that's going to have an impact on wildlife and would be something we would seek to minimize the risk of, given the you know, the sensitive nature of the ecology in that area, because of the fact it's right next to Farnham Park. And I don't know how we manage that. It's not really covered by the lighting condition we discussed earlier, because that's relating to buildings. So I would just like you to consider that in your final assessment of what the wording should say. It's obviously not relevant in this.
And just in terms of the restriction for preparation of burials, do you have anything in mind that you think it should be?
I think it's really difficult, because I think that it depends how often it is, how, you know, how disruptive it is, what time of year it is. I mean, I certainly don't think that we should be allowing people to arrive at the site before 8 a.m. under any circumstances, because that's really very early in the morning for the other people who live locally, and that isn't what was in the original condition. But, you know, I think it is a judgment that obviously you need to make. You know, there was discussion about early hours of the morning. I mean, that could mean anything. I would say that most community buildings, it's normally 8 a.m. So if we're considering this in any way, shape or form to be a community building, I would suggest 8 a.m. And I think 6 p.m. is probably a reasonable time to be leaving, although there didn't seem to be any indication that they would necessarily be doing body preparation any time other than in the morning. But again, that's
it certainly did sound like it was morning, just because of how it potentially operate. But my assumption is it could. I don't know. It's not for me to really speculate, and it's maybe a point for clarification. I can let the council see if the council have got anything further to add on that point. Why it hasn't suggested anything of that nature, and then allow Mr. Steele to have the final response on it.
Can I just say one thing?
Yeah, one more before it goes back to the council.
The other thing is the bit about people using the building for body preparation. I think that should not be allowed on Sundays, and it should not be allowed on bank holidays in the same way as this digging proposal applies, because I think that that's part of the, you know, the intent behind this is to minimize the impact on local people. And I think that that is important. If you could consider that, sir, I'd appreciate it.
Thank you, Councillor Powell. I'll throw it back to the council first for any comments, and then onto Mr. Steele if there's no other comment, no other hands raised. Mr. Collett.
Thank you. So just picking up on Councillor Powell's last comment about body preparation on Sundays and bank holidays. My understanding is that actually only happens on the day of the funeral itself, and obviously we have got restrictions on when funeral ceremonies can take place, but I'm happy for you, sir, to reflect on the need for any additional wording there. In terms of when the preparation process can take place, we heard some very detailed comments from the community as part of the inquiry, and clearly there are sensitive processes that happen, and the restrictions were largely around traffic generation and the timing that happened, and the level of people involved in body preparation is obviously significantly less. And we weren't looking to restrict when that process happened. It was more when there was more travel to the site for the funeral ceremony itself, which clearly attracts significantly more people. Again, sir, if you think there is a need to restrict timings, we're happy to leave that to you, but it's not something that we're.
Well, it's more a case of if you thought it was necessary to suggest by submission next Friday, which doesn't appear to be the case.
No.
I'm happy to reflect on it, and obviously, if there isn't anything in the submissions next Friday, that doesn't restrict me for considering it and suggesting if there is a need for it, should I consider that the case if I were allowing the appeal contingent upon such a restriction. Mr. Steele?
Thank you, sir. Yeah, I have nothing more to add. You've got the evidence before you've heard the evidence, and the appellant would feel it's completely unreasonable to restrict those volunteers that are preparing for the funeral as described in the evidence. Thank you.
Thank you, Doctor. I'm happy to take that away and reflect on the respective conditions and the evidence that's before me, unless there's any further comments to add on condition 11. There's no hands, so in that case, Mr. Steele, if you can deal with the final condition that's listed in document IQ 13, yes, please. I think that's condition 12.
That's correct. Condition 12: the site shall not be open for a visitor outside the hours of daylight. So the suggested condition here is the burial area shall not be open for visitors. And then the council has included not attending a burial ceremony outside the hours of daylight. And the council has included that addition so that it doesn't impede on attendees to the funeral that may also visit the graveside outside.
And in turn, the council may want to explain this rather than yourself, but is that in case on certain times a year that daylight's lost towards the end of a burial process? Because obviously there's a suggested condition already to restrict the funeral ceremony taking place between 10 AM and 4 PM, and obviously hours of daylight sometimes do go sometimes after 3, for example. I'm just trying to understand that. Obviously the burial does sometimes continue after the ceremony is complete, and so on. There are the finalization of the process can take more time than the actual ceremony and the burial process itself, the filling in, for example, of a grave, etc. But I was just wondering the purpose of it, because obviously I understand the purpose of the original condition 12 on the planning permission, because that related to the woodland burial site and the ceremony itself. So it was very clear in terms of no one there outside of daylight. But obviously this proposal does have an introduction of a different use, and there is a need in terms of visitors. Do you classify people who are preparing for the funeral as visitors, for example? And why? And I'll let the council explain their addition, but I'm just trying to understand that interaction, because my assumption is it's more to do with visitation of the graves that the concerns arise in, that it's not crossing over on that. And I wonder whether that just should be, because it does refer to the burial area rather than the building. So it's whether that's precise enough or not. I'll invite comments on that from the council firstly, and then if any interested parties have got any comments on it, and then I'll allow you to have the final say. Mr. Collett?
Thank you, sir. I have to say, yeah, your assumption is correct. We were the addition was made to the suggested wording, because everyone attending a funeral is a visitor to the site. And what we didn't want was any disparity with the condition that relates to funeral ceremony buildings and the use of the pavilion, restricting the ability then for people to go from that funeral ceremony to the graveside for the burial ceremony itself. And for the exact reasons that you've mentioned, probably, yeah, in the depths of winter, probably this time of year, daylight is short. And what we wouldn't want to do is restrict the ability for people to attend the actual burial process. And actually, the condition is really aimed to control when people are visiting graves outside of a funeral or burial ceremony.
Yeah, no, I do understand that, and my assumption is that you see to be a material difference there. That, for example, a formal funeral ceremony and then the process in terms of people moving to the grave may take longer than a scheduled pure ceremony at the site itself, which obviously would need to be scheduled within daylight. I can understand that, and obviously it'd probably only be a difficulty at a particular narrow time of the year. But I can understand. I can understand in principle why that was suggested. It's more the case of how it then broader interacts. But it's the question about the fact that it refers only to the burial area might be the clinch on that, really. Councillor Powell?
Yes, I mean, I think just one thing I would like you to reflect on is the fact that, you know, the community is very clean that this area is not completely fenced off, and that's obviously something that you will consider as part of what you've heard. I wouldn't want the wording of this condition to in any way encourage the fencing off and the restriction of access to this area. All the other graveyards in Farnham are open access 24 hours a day, 7 days a week. We don't actively encourage people to go into them at night, but they are open access. So I just would like you to reflect on the wording in terms of what it's trying to achieve versus any impacts it might have on other conditions inadvertently.
In suggesting that, are you suggesting the condition shouldn't be imposed at all for that reason?
I am concerned that it could drive fencing being installed when I don't think any of us feel, certainly not 6 foot high deer fencing is required, because we very much value it as a green corridor. And obviously, as I've already said, the highways officers wanted a condition for a public access route through the site. So I wouldn't want it to come across as something that would restrict those possibilities, sir.
Noted, Councillor Powell. Mr. Steele, any final comments on what you've heard there?
No, to be honest, I don't have any words of force on the matter, sir. Unfortunately, I've got nothing to add on it.
Yes, it's just noted that there is an existing restriction on the burial area via that planning permission, the previous planning permission. So I will reflect on that and what it means in terms of the interaction between the two sites and whether it's necessary at all, given the nature of the existing restriction. Happy to reflect on that if there's no further suggestions. That does come to the end of IQ 13 as far as I'm aware. So now's the time for any wider comments on the document 9.1, if there's anything that anyone perceives as being omitted, although noting we have had discussion in the round as part of evidence on quite a number of those conditions. So if we can desist from getting too deep into repeating some of those discussions, because I've heard it and I will take it into account. Councillor Powell?
Yes, I'm respectful of your time. I won't take your time to do that. I think that we've discussed condition 10 at length, and I will leave you to go away and consider that in your own thoughts based on what we've already discussed. But there are 2 other conditions we haven't discussed. One is condition 3. Condition 3 is essentially about the maintenance of fencing to the north, northeast and northwest of the boundaries. And it says that that fencing would be approved within 2 months of commencement. We're obviously many years into commencement, and that has not as yet been done. I am concerned that although it is not in the red line boundary for this application, it is within the ownership of the applicant. And it's another one of those where I don't know, if we don't fix it now, what do we do? It kind of leaves things in limbo. So it was more a request for you to think about it than necessarily a proposal.
I have thought about it, but I would be guided by firstly the council's comment on this, whether that's a matter for enforcement action or rather than something that's within the control of this particular application. And obviously enforcement action will be at the discretion within the legal boundaries of what's capable by the council, rather than something that can be dealt with specifically by this appeal. Mr. Collett?
Thank you, sir. I agree in terms of enforcement. Details were approved as part of condition 3. There is an implementation timescale. If that's not being complied with, that is an enforcement matter. But also, as the boundaries are outside the red line of the appeal, I'm not sure that condition could be reimposed in any event on any consent. But I think, yeah, it certainly is an enforcement matter for the local authority to look into.
Thank you. Councillor Powell, before I throw it across to Mr. Steele.
No, sorry, that's an old hand. I have one more thing to raise, but please go to Mr. Steele first.
Okay, no problem. Mr. Steele, just on this this condition about maintenance of fencing, condition 3.
Yes, so I would agree with the council in that respect, that it is relating to the other permission and land outside of the red line for this application. Yeah, so nothing to add. So
thank you. Noted. Thank you. Back to Councillor Powell. Then your other point.
Sorry, this is the last one, I promise.
No, that's fine.
So it's condition 14, which relates to archaeology. I haven't seen anything associated with this particular application to resolve this particular issue, unless I've missed it, which I may well have done. But I would just like you to consider that, given the historic nature of some of the site. So
the parties may want to confirm to me, but I vaguely, in reading the evidence earlier, and I will return to it, did see I thought I saw a consultation response that suggested a condition wasn't required, and this could be picked up potentially in the submissions next Friday if things not taken forward, just as clarification. I thought I'd seen something that some works had been undertaken as part of a previous permission, and that was the reason why the consultation response hadn't suggested a condition. But I may be wrong on that, so I'm just looking for the parties to assist me, because obviously we read a number of different cases and sometimes we can confuse. So, Mr. Collett?
Yeah, I think you are right, sir. There was no suggested condition on archaeology. I would just, obviously going back to condition 14, just talk about development taking place until a programme of archaeological work is being implemented. And as the consent has been implemented, I would assume, and I don't know, so I can check back the archaeology consultation response before next Friday, but I would assume that that's been appropriately discharged to enable the extant consent to be implemented.
That would be my assumption as well, because if there's a pre-commencement condition and there's a common position between the parties that the consent's been implemented, then typically pre-commencement conditions need to be discharged for that to happen. But yeah, I'd be grateful if that could be checked and if it can be clarified by the submission next Friday. Final comments, Mr. Steele?
Just that we've got the consultation response from Surrey Archaeology CD 4.2, which confirms what Mr. Collett's just said.
Thank you.
Thank you. I can take that away and review it as well. So grateful for that. There's no hands, so I'm assuming that we've explored all we need to explore on CD 9.1. So that does conclude the conditions session. We've no hands remaining and there's no comments apparently anyone wants to make at this point. So the time's 14:49. My suggestion now, Mr. Banner and Mr. Green, I thank everyone for the contributions to that session. It was worthwhile and assisted my understanding of where we stand in terms of those. And I thank the Council of the Appellant as well for their ongoing work since day 4 in providing an accurate position of where we were in response to my inquiry. I don't underestimate the amount of work that went into that. So I thank you for that. Mr. Banner and Mr. Green, given it's 14:50 now, 10-minute break and then take closings from 3 p.m.
Sounds good to
Yes,
me.
sir.
Thank you, sir.
Thank you. Well, in that case, 14:50, the inquiry is adjourned until 3 p.m. Thank you.
Thanks, sir.
sir.
Right, good afternoon again. We're just approaching 3 p.m, so it's time to resume the inquiry. Just before we move on to closing submissions, just checking there's no housekeeping matters that have arisen towards the end of the previous session and over the short adjournment.
No, sir.
No, thank you. Well, in that case, moving on to closing submissions, can I ask the council please to begin your closing submission? Thank you.
Thank you, sir. The main issue between the appellant and the council in this appeal is the effect of the proposed development on the character and appearance of the area, including the area of great landscape value, or AGLV, and area of high landscape value and sensitivity. Third parties have raised other concerns, but these submissions are necessarily confined to the council's case. So starting with the appeal site and wider landscape. The appeal site is almost entirely undeveloped countryside and comprises 3 agricultural fields and an access track and parking area leading to Hale Road. Save for fencing, the fields are devoid of above-ground structures. Immediately to the northeast of the appeal site is an electricity pylon. Farnham Park lies to the west, Hale to the north, and Lower Hale and Farnham to the south. The appeal site sits within the North Farnham Rolling Clay Farmland Character Area, LF6, in the Surrey Landscape Character Assessment, segment FN8 of the Waverley Borough Council Landscape Study Part 1, and Landscape Character Area 6, known as Cemetery Fields, in the Farnham Landscape Character Assessment 2018. The last of these studies is the most fine-grained and includes a description of the key characteristics of the Cemetery Fields character area and an assessment of its landscape sensitivity and value. Notably, the character area consists of small fields in pasture bound by hedgerows of varying ages. The character area is bound by settlement to the north and south and by the A325 to the east. Settlement within the character area is limited to the occasional large detached dwelling. The settlement does not affect the perception of rurality within the character area. Under landscape sensitivity, the study says, the character area is generally in good condition, although some areas appear unmanaged. The character area forms a critical part of the separation between Farnham and Hale. The character area forms a rural setting to adjacent settlement. The character area contains some existing features which could be built upon to mitigate development. However, new development would be likely to harm local character. Its sensitivity is given as high. Under landscape value, the study says, the character area lies within the AGLV and an area of high landscape value and sensitivity. It's a peaceful and attractive rural landscape and is small scale and enclosed. The character area forms part of the distinctive rolling clay farmland, which forms a green wedge between Farnham and Hale. Its landscape value is also given as high. The appeal site and wider landscape have been considered in a number of appeal decisions since 2010. When granting permission in October 2010 for the change of use of land within and beyond the appeal site to a cemetery and woodland burial site, the inspector described the land as an extensive area of open land, crossed by hedges and set with some mature trees. It's predominantly open grassland, sloping gently upwards from the main road, Hale Road. The site is located on the outskirts of Farnham, plainly outside the built-up limits of the town, where countryside policies apply. The proposed development was considered acceptable by the inspector because the project would preserve the rural nature of the setting and maintain its countryside character. In an appeal decision in March 2018 concerning residential development on part of the current appeal site and land to the north, the inspector considered that the development would be within a valued landscape and cause considerable harm to the character of the area, to which he gave significant weight. In September 2023, an inspector dismissed an appeal relating to the residential development of land to the north of the current appeal site, southeast of Oast House Lane. The inspector described the land to the south, that is embracing the current appeal site, as comprising gently undulating open grassland with some more wooded areas beyond. The Oast House Lane site was part of the verdant countryside beyond the build-up area, and the development would represent a harmful incursion into the countryside that would not protect or respect the AGLV designation, would cause harm to the character and appearance of the area as a whole. The only appeal in which permission was granted for development within the AGLV relates to the Hawthorne site to the south of the current appeal site, comprising a substantial detached house, its garden, adjoining paddocks and meadows. The inspector considered that the two meadows in the north and east have the character of small rural fields. They are part of a rural landscape that includes the Nadder Stream and Farnham Park, and exhibit some of the key characteristics and positive attributes of the North Farnham rolling clay farmlands landscape character type, defined in the Surrey Landscape Character Assessment. These two meadows were of high landscape sensitivity and high landscape value, and the inspector agreed that this part of the site is part of a valued landscape and justifies being identified as an area of high landscape value and sensitivity in the Farnham Neighbourhood Plan. The remainder of the site was not characteristic of the landscape character type and was of moderate sensitivity and value. In light of this, the inspector concluded that the appeal site could be developed in a way that would focus the development on those parts of the site of moderate landscape value and sensitivity, with the encroachment into the more sensitive and valuable parts being minimised or capable of being softened through mitigation. All these appeal decisions recognise the importance of the undeveloped rural character, sensitivity and value of the land within the AGLV and the area of high landscape value and sensitivity. None of them provides any support for substantial built development within the middle of it. I turn then, sir, to the 2010 Planning Permission. The appellant relies on the Planning Permission, WA 2010-0166, granted on the 5th of May 2010, for the change of use of agricultural land to cemetery and woodland burial site. It has been agreed that this permission was implemented, although no burials have yet taken place. The permission relates to the following area of land as shown on the amended master plan. The 2010 permission is subject to a number of conditions which require the subsequent approval of various landscaping details. These were approved on the 7th of February and 31st of March 2011, and pursuant to these conditions, the landowner must, among other things, plant the site in accordance with the approved planting scheme and phasing plan over a 5-year period, that's conditions 1 and 10, and maintain the site in accordance with the approved landscape management plan, conditions 1, 2 and 10. Evidently, the requirements have not been fulfilled, have not been fully complied with. Had they been, the condition of the landscape to which Ms. Ritson draws attention in her table B1 would have been improved. The current proposals are not consistent with the details approved under the 2010 permission. A comparison between extracts from the appeal site plan, which I give, and the approved phasing plan, shows that the funeral ceremony building would require the removal of a hedgerow, which is meant to be retained, and would intrude into areas of planting within phases 1 and 3 of the approved planting scheme for the 2010 permission. The proposed paths shown on appeal site plan, and I give the number, would also cut across an existing hedgerow and approved planting. More broadly, the two schemes involve very different landscaping proposals. The upshot is that the appellant wishes to rely on the 2010 permission for the consented grants for the use of land as a cemetery and woodland burial site, but will not comply with the ongoing landscaping requirements imposed by that permission. Instead, a contradictory landscaping scheme is proposed, creating a potential enforcement dilemma for the council. This could have been avoided had the appellant come forward with a comprehensive scheme, that is, for the construction of the building and the conduct of burials, for the land covered by the two permissions, but that is not what the application is for. I turn then to the proposed development and its likely impact. As I stated in opening, the proposed development consists of a large funeral ceremony building, car parking and access works, and landscaping. The building would be 9.1 metres above ground level, with a front elevation 42 metres wide and a side elevation 35.4 metres wide. The steeply pitched roof would be 6.6 metres from eaves to ridge, more than twice the height of the ground floor walls, which are 2.5 metres tall, and is proposed to extend 12.5 metres over the access road to the front. The building would have a gross external area of 461 square metres, a gross internal area of 382 square metres, and the combined capacity of all the rooms would be approximately 365 people. The maximum funeral attendance modelled by the appellant's witnesses was said to be 181 people, although it became clear that a greater number might attend on occasions. The building would be significantly bigger than any other building in the vicinity. In addition, formal parking areas along the accessway from Hale Road are proposed to accommodate 75 cars, and internal paths would be covered in tar and chip. The rationale for the design of the building is perhaps best summarised, albeit with some possible contradiction, in paras 333 and 629 of Mr. McLaughlin's proof of evidence. To inform the pavilion's form, we reference rural and agricultural buildings that befit the history of the wider site and its surroundings. The thatched roof will be consistent with local historical precedent. It's important to note that as the typology of the proposed pavilion is without local precedent, it was necessary to look beyond the immediate locality for appropriate expression. The use of thatch and timber cladding is synonymous with rural and semi-rural areas and carries agricultural connotations for the layperson. We therefore found it appropriate for this setting, as it would allow the building to assimilate into its wider semi-rural surroundings and befit its historical context. As Mr. McLaughlin accepted in cross-examination, the proposed design is not the only appropriate design response for a funeral ceremony building, and there are two chosen features in particular that have led to a particularly bulky structure: the thatched roof and the roof projection across the access drive. As stated, for example, in the appellant's design statement of case at para 2.2, the thatch extends over the pavilion's entrance area, creating a covered arrival portico on the intersection with the approach path. The gradient of the main roof's pitch is determined by the minimum slope required for a thatched roof to adequately shed water. Thus, the building's overall height is a function of the necessary span across the main hall sized to accommodate the anticipated number of funeral attendees. The pitched roof is in keeping with those of surrounding structures, both in inclination and scale. It's not, of course, for the council to put forward alternative design proposals. Ultimately, what matters is the likely effect of the proposed building on the character of the area. Nonetheless, design choices have been made, and the result is a building of substantial scale and bulk. Thatch is not characteristic of buildings in the area, and with different materials, the roof could have been shallower. A far more modest canopy could have protected the entrance area. Even allowing for the functional need advanced by the appellant does not follow that the building minimises impacts on the character of the area. To an extent, it is common ground that the erection of the proposed building and ancillary works on what are currently open fields will be harmful to the character of the area. The parties disagree on the extent of the harm, but as you, sir, have visited the site and surrounding area, and will form your own view based on the paper proposals and what you have observed, it would not be a sensible use of time to go through the landscape evidence in any detail. Turning to the policy context, policy RE1 in the local plan, part 1, seeks to recognise and safeguard the intrinsic character and beauty of the countryside, consistently with para 187B of the NPPF. Policy RE3.2 requires new development to respect and, where appropriate, enhance the distinctive character of the landscape, and in the case of AGLVs applies the same principles for protection as AOMBs, while recognising an AGLV is a local landscape designation. Neighbourhood Plan Policy FMP1A requires development proposals to respond to the distinctive character of the individual area of Farnham in which it's located. Policy FNP10D provides that outside the defined built-up area boundary, priority will be given to protecting the countryside from inappropriate development, permitting new development only where it retains the landscape character of and does not have a detrimental impact on areas of high landscape value and sensitivity. Summarising the 2018 landscape character assessment, the appeal site is part of a peaceful and attractive rural landscape comprising small fields and pasture bound by hedgerows of varying ages. This landscape forms a critical part of the separation between Farnham and Hale. The proposed funeral ceremony building would constitute a substantial intrusion into what are open fields, adding to sporadic development between Farnham and Hale. The council is right to say, therefore, that the size and scale of the proposals, including the ancillary infrastructure, would detract from the openness and character of the site. As to what was meant by openness, this needs to be approached with a degree of common sense. Case law and national guidance on openness within the Green Belt indicate that it can have both a spatial and visual aspect. There's no reason to suppose that in referring to openness and the reason for refusal, the council was seeking to apply a more restrictive meaning than this. nor can one sensibly divorce the physical changes to landscape character from the perceptual. The absence of a reference to views in the decision notice does not mean that the effect of the development on the character of the landscape as it is actually perceived is to be ignored. Then so the issue of the baseline or fallback. Although I have not sought to explore the witnesses' judgments on landscape matters in these submissions, you'll be aware that there's a difference between the parties as to the appropriate baseline, both in assessing the harm likely to result from a development and its ecological benefits. As already touched on above, the 2010 permission comes with an approved landscaping scheme. Although Farnham Cemetery Limited, through which the appellant controls the appeal site, acquired the land in 2020, that landscaping scheme has not been fully implemented. Its intentions, should the appeal fail, are unclear, but given the stated need for a new burial site, there's no reason to suppose that the appellant will simply abandon the site if permission is refused. Instead, the more realistic outcome is that the appellant will make best use of the appeal site in accordance with the 2010 permission. And it's this scenario that should be taken into account, either in assessing the baseline or in assessing the weight to be given to proposed changes in the appeal site. So whether there is compliance with the development plan taken as a whole. For the reasons given above, the Council submits that the appeal scheme would cause significant harm to the character of the appeal site and AGLV and area of high landscape value and sensitivity, contrary to policies RE1, RE3, FNP1 and FNP10 of the development plan. It would therefore not be in compliance with the development plan taken as a whole. I turn then to other material considerations. In support of the appeal scheme, Mr. Steele argues that the following material considerations would justify the grant of planning permission in any event. The funeral ceremony building will be a community asset, exceptional design quality, church car parking, safeguarding against coalescence, biodiversity net gain or BNG, and carbon offsetting. And I shall take each of these in turn. Starting with the alleged community asset. It's accepted that the funeral building will be of benefit to the Ismaili community in the southeast of England, but it will not be a community asset for the people of Farnham, nor does it amount to infrastructure or a community facility within local plan policy ICS1. Since 1984, Ismaili burials have taken place at Brookwood Cemetery in Woking. We are told that concerns about capacity of that cemetery led to the search for a new burial ground. The appeal site was chosen because it already had planning permission for this use and was relatively close to Woking. The site was acquired for the purpose of using the land as a burial ground. It was only after its acquisition that the appellant formed the idea of constructing a funeral ceremony building on the land. We're told that the building would perform two main functions. It would provide a facility for the ritual cleansing of the deceased, the ghusl ceremony, and it would accommodate the funeral ceremony. Both functions are currently performed at several locations in London and the surrounding areas. Such evidence as there is suggests that existing arrangements work well. Mr. Bhatia spoke of the seamless and complete coverage by the dedicated and compassionate volunteers who facilitated the funeral of his mother. Nonetheless, it was asserted that it was inconvenient and potentially unsafe for volunteers to have to travel to different locations to perform the ghusl ceremony. But there was no evidence that anything untoward had happened in the past 40 years, and inevitably a facility in Farnham is going to be less convenient than facilities closer to the homes of those who volunteer. The space needed for the ghusl ceremony is relatively small, and had the safety of volunteers really been a concern to the appellant, it could have acquired or leased a dedicated property for a fraction of the cost of the appeal scheme, as Mr. Givraj accepted in cross-examination. Although very little is known about existing locations used for the purposes of Ismaili funerals, the Council does not contest the general point that a purpose-built funeral ceremony building next to a burial site is likely to be more convenient for those who wish to attend or observe the burial than a building further away. And we are told that the glass doors at the rear of the building will allow women and the infirm to view burials taking place in the central part of the site, whereas this is not possible at Brookwood. These benefits are accepted. What is not accepted is the assertion that the proposal represents a community facility of the sort contemplated in development plan policy. The purpose of the development plan is to plan for the needs of the borough and any cross-boundary needs that are agreed to be met. Unsurprisingly, therefore, Chapter 8 of the Local Plan Part 1, which concerns infrastructure and community services, begins: the development proposals of the local plan, and in particular that part of the strategy that delivers the housing target, will increase the pressure on existing infrastructure and services. Where development is proposed, and especially where services are already under pressure, the plan needs to demonstrate how the social, economic, and environmental infrastructure to meet borough-wide and local needs will be provided. Sustainable development aims to support strong, vibrant, and healthy communities with accessible local services that reflect the community's needs and support its well-being. To achieve this, the right community facilities and other local services must be planned to enhance the sustainability of communities and meet local needs. The text of policy ICS1 should be read with this in mind. Until the appellant acquired the appeal site in 2020, it's not contended that it had a particular association with Farnham or the district. The appeal site was acquired as a place of burial for Ismailis in London and surrounding areas. In no meaningful sense could the site be said to cater for a local need or the needs of a community in Farnham or Waverley. The suggestion that in referring to new services and facilities where required, Local Plan Policy ICS 1.4 had in mind a facility that could be located anywhere within the vicinity of the M25 and is intended to be used by Ismailis across the southeast of England is little short of absurd. Whether or not the funeral ceremony building falls within the definition of infrastructure in paragraph 8.3 of the supporting text to ICS1 is of academic interest only. As the point has been raised, however, I will say a few words about it. Cemeteries appear under the headings Public Services and Green Infrastructure, which indicates that they would not be expected to come with significant built development. The funeral building will not function as a mosque, and it's not a place of worship. Rather, it is a place of leave-taking. The appeal scheme does not therefore fall within the definition of infrastructure, but policy ICS1 is inapplicable for the more fundamental reason that it's intended to cater for infrastructure and community facilities that are required to support new development and meet local needs. The appeal scheme does neither. Finally, and contrary to what might be said by the appellant, the public sector equality duty in section 149 of the Equality Act 2010 does not add weight or rocket fuel or any other propellant to the consideration of this factor. And that's why I set out section 149(1) in the text. The public sector equality duty is not a duty to achieve a particular result. It's a duty to have regard to the need to pursue the policy goals affirmed in the 2010 Act. If an inspector subject to the public sector equality duty properly considers the relevant matters, the weight to be given to each factor is entirely a matter for their planning judgment. Moving on then to the issue of exceptional quality. The Council's objection to the appeal building is to its size and scale in a valued and sensitive landscape. The fact that in other respects the building can be said to be of high or exceptional quality does not reduce or overcome the harm caused. The provision of car parking for the Church of St. John the Evangelist would be of benefit to the users of the church, but would add to the impact of the proposed development on landscape character. It's not essential to the proper functioning of the appeal building and is not needed to make the development acceptable. It's not something, therefore, to which much weight could be given. Then safeguarding against coalescence. It requires a certain bravado to argue that substantial built development in the gap between two settlements is needed to help prevent them from coalescing. In reality, and contrary to what Mr. Steele claims, the proposal would not preserve the visual setting and landscape features in the undefined settlement gap between Hale and Farnham. It would harm them. What would preserve the gap is full implementation of the cemetery and woodland burial scheme permitted in 2010. But even if the appellant is unwilling to do this, dismissal of this appeal would help. Next, biodiversity net gain. For the reasons given above, it's submitted that the weight to be given to biodiversity net gain as calculated by the appellant should be tempered by the fact that there is an approved and partially implemented landscaping scheme under the 2010 permission. If the appeal were dismissed, the appellant and wider Ismaili community would still benefit from the use of the appeal site for burials in accordance with that permission. It should not be assumed, therefore, that improvements in the site's biodiversity are dependent on the appeal scheme. Lastly, carbon offsetting. Without knowing what carbon emissions would be likely to be generated by the appeal scheme, and comparing them with the emissions likely to be generated in a no-scheme world, it's impossible to arrive at any sensible conclusion on this issue. Nonetheless, Mr. Steele still suggests moderate weight to be given to this assumed benefit, which says more about his willingness to go the extra mile for the client than it does about the merits of the appeal scheme. So my concluding submissions. The appeal scheme is for a large building and ancillary development in a well-defined AGLV and area of high landscape value and sensitivity between two settlements. It would intrude into the open pastoral fields that are characteristic of this rural area, causing significant harm. It's contrary to a number of development plan and national policies that seek to protect this sensitive and valued landscape. The Council accepts that some members of the Ismaili community in London and surrounding areas would find the appeal building more convenient than existing arrangements. For them, it would be a benefit. It would not, however, bring any wider advantages, save in the original proposal for car parking for St John's Church. The positive aspects of the scheme are acknowledged, but it's submitted that they do not justify harmful development that fails to accord with the development plan. The Council therefore invites dismissal of the appeal.
Thank you, Mr. Green. That's all. That's sorry. That's all noted. Mr. Banner, would you like to begin your closing submission?
Yes. So the first part of my closing submission is entitled "The Need for and Importance of the Appeal Scheme." And so there was rightly no serious challenge at the inquiry to the clear, convincing, heartfelt, and indeed often moving evidence of Mr. Jivraj and other members of the Ismaili community explaining what this scheme would mean to them and why it's so important. You've heard how the preparation of a body for burial, the ghusl, and the subsequent funeral, burial, and post-burial rituals are sacred and spiritual processes of fundamental significance to Ismaili's religion and culture. The Ismailis who live in the southeast of England currently don't have a single location where these processes can take place. Burials take place, as you know, at the Ismaili cemetery at Brookwood in Woking, but that's approaching capacity. And further and fundamentally, there's no accompanying building where the body can be prepared. You've heard how this has to be done off-site in third-party premises, which vary in quality, availability and location, meaning that the volunteers involved in the ghusl process have to travel to multiple locations, often in the middle of the night. You've heard from the people involved themselves in this process and the sincere and justified concerns they have about their safety and welfare under the current arrangements, as well as the stresses and difficulties involved. Also, there's no single consolidated location where the funeral service can take place. Due to the lack of appropriate facilities at Brookwood, the funeral service is carried out after the ghusl process in different parts of London and the surrounding areas before the coffin is transported to the cemetery, with members of the congregation travelling there separately by coach, minibus or in their own cars. And you've heard how having to hold the various processes in different locations drags out what's already an emotional and stressful experience, making it even harder for people to say goodbye to their loved ones and putting unnecessary pressures on the essential ghusl volunteers who, as you've heard, their role extends to the funeral service as well. There's no consolidated location for where women who under Muslim culture aren't able to be at the side of the grave during the burial, and indeed those who are too infirm to physically be able to do so, can observe the burial. And Mr. Jivraj explained the sensitivities of this issue to you in his oral evidence. You'll recall how he said that the Ismaili Muslims are a minority amongst the different branches of Islam. Most of them live in parts of the world where religious practice remains conservative, such as Afghanistan and Syria. And what the Somali community does here in the UK as modernist Muslims needs to take careful account of how it will be interpreted in those places and the risk that it could have adverse consequences such as persecution for Somalis living there. By comparison, the suggestion that the council in cross-examination that women could watch the burial from standing afar behind a line, whilst no doubt made with the best of intentions, is misinformed and misconceived, as Mr. Jivraj explained. The compromise that His Highness the Aga Khan has approved in signing off the proposal for the appeal scheme is for women to be able to watch the burial from behind a glass screen, which provides a coherent and defensible principled line, which is defendable from adverse interpretation in the more religious parts of the world, more conservative parts of the world, sorry, that I've described, such as Syria and Afghanistan. And yet it does provide an opportunity for women to watch the burial. It strikes a coherent line between those two considerations. Whereas the line on the ground approach suggested by the council thus far and no further, you'll recall in the cross-examination of Mr. Jivraj, that doesn't have that same principled distinction as watching behind a glass screen. And it also raises the unseemly and undignified spectre of bouncers in an already emotionally charged situation enforcing the separation, having to restrain anyone who, in seeking to get a better view, strays over the line. Mr. Jivraj spoke profoundly, sir, about the challenges facing the Somali community in securing the future of the practice of its faith in an era where its younger generations live in a Western context with broader relationships than previous generations, placing competing demands on their attention and time, dealing with the very real and substantial challenges in relation to the process of bidding farewell to loved ones is a key part of this. A single consolidated location in a building and location which are both beautiful and peaceful will be truly transformative for the Somali community. And dismissing all of this as a mere convenience, as the council's closing submission does, would be to shut one's mind to the clear and largely unchallenged evidence provided to the inquiry about its importance, the dignity and well-being of the Somali mourners, and for the long-time future of the Somali community. I turn then to the scheme, its concept, design, and sustainability, and the appeal site shows a logical place to deliver the objectives that I've outlined. It already got an excellent consent for burials. It's well located to serve the needs of the Somali community in the southeast region, and it lies in the landscape character area, LCA 6, promisingly known as Cemetery Field. It's also adjacent to another religious building where funerals take place, St. John's Church, which has an accompanying graveyard. You've heard from Mr. Jivraj about the value that Muslims generally and the Somalis specifically place on architecture, and this is reflected in the real care applied in the design of the appeal scheme. Mr. Jivraj explained how whilst the building needed to be appropriately spiritual, there was no fixed preconceived design, the proof of the pudding being that the vernacular ultimately selected is what he describes as a barn, not a dome. Nor was there a fixed location within the site where the building would go. The Trust had an inclination that the area where the pavilion is now proposed would be the right location, given it's a low point on the site, whilst having expansive views out towards the burial area, but they left it to the selected architect to make the final recommendation as he did. And that select architect is someone at the very top of their profession, of worldwide renown. Neil McLaughlin, MBE, member of the academician of the Royal Academy, 2022 Sterling Prize winner, who has distinguished experience of designing sacred buildings such as the new Faith Museum at Auckland Castle, Grade 1 listed building and an RPG, which won the Royal Fine Arts Commission Trust National Award for the most beautiful building in Britain last year. And the proposal that he's prepared for this site is truly exceptional in the quality of its design, as was recognised in the officer's report recommending the grant of permission. For example, the agriculture-inspired form, the natural external materials made from sustainable, locally derived sources wherever possible, take appropriate account of the site's context and enable the pavilion to blend into its woodland setting. The building is sited in the lowest part of the site, as you've heard, adjacent to existing and proposed tree belts, and its footprint amounts to less than 1.8% of the site, around 4.4% of the landscape character area. It's highly sustainable, with the materials for its primary structure, cladding and roofing chosen for their exceptionally low levels of embedded carbon, and for its fenestration and roof design facilitating natural ventilation. And the associated landscape design, prepared in collaboration with Kim Wilkie, one of the country's most esteemed landscape designers and another award winner, draws from the site's history, looking to past centuries when the site was more heavily populated with trees. A range of native woodland species will be planted, amplifying the carbon sequestration potential of the site and the scheme. Now, my dry lawyer's prose, you just heard, so it's no substitute for the powerful description that the architect himself gave you in his evidence in chief presentation of the key drivers for his design of the proposed development. So to quote him, because he put it far better than I can, at the outset of our employment, we developed our interpretation of the landscape. As an architect, I understand landscape not as trees and hedges, but as all the visible features of an area of land, primarily considered in terms of their aesthetic, ecological and social context. It includes, in this case, the enclosed fields, the boundary trees and the champion trees, the pylons, the adjacent housing development, the more separated buildings visible around the character area, the heritage assets, the open views towards Surrey Hills to the south, and the episodic views to and from Farnham Park. I understood that we should design a combination of building and enclosed fields that would communicate to a passing viewer a sense of a tranquil rural setting. I don't consider rural settings in England to be absent of buildings. Fields, hedgerows, coppices and buildings that relate to the practical use of the land form the tapestry of our rural landscapes. And this funeral building, like barns, stables, farms, sheds and yards, is a structure with a practical purpose directly related to the land on which it sits. We saw it as a natural rural building type. Based on our understanding of landscape characteristics, we positioned the building at the lowest point on the site, looking up and towards the burial ground. This means that the highest ridgeline of the building is a ground level when seen from the northern boundary of the site, looking south towards the distant hills. It's beneath you. We understood that the views of the distant hills are over the field enclosures as well as through them. We lowered the ground level of the building to the lowest practical point to ensure we minimise the perceived volume. We also designed the walls to be exceptionally low. This means that the eaves of the building come down quite low too. The sloping roof has inherently less volume than the vertical walls. We carefully considered the approach from the entrance to the site to the funeral building. We designed the car parking as a natural extension of the existing parking around the hotel. The new parking is on a permeable gravel surface. The path leading from the car park to the building was given careful consideration by digging a small ditch and mound on each side. We emulated old country lanes. We'll plant the ditch with oak trees, which will in time grow over the lane to create a little holloway, which will disappear from visibility. I was especially concerned that it should be as narrow and modest as possible, because I wanted mourners to feel they were moving out towards a secluded and tranquil place. We debated this thoroughly with the client. The lane is made just wide enough for a vehicle to pass pedestrians safely at a very slow pace. Its passing points to avoid congestion. Vehicles are for older and disabled mourners only, others will walk. The surface has a bound gravel appearance similar to what's commonly used on National Trust estates. We worked with the esteemed designer, Kim Wilkie, to create a landscape setting for the burial. Apart from his design and teaching, he's involved in various national committees on landscape and environmental policy in the UK. He proposed only native species of oak, crabapple and hawthorn for trees and hedgerows. Our planting carefully reinforces the site boundary by thickening the depth of trees and bushes at the edges. It creates an inner field surrounded by woodland with smaller clearings opening off it. The point where the tree-lined lane connects the field, we placed the pavilion framed by trees on two sides. Now, so the council's case of this inquiry has at its heart the reference in the DAS to the proposed scale being the functional minimum. Their suggestion, that's the council's suggestion, being that contrary to the analysis in the DAS and Mr. McLaughlin's evidence, the development could in fact be smaller. Now, a fatal flaw in this analysis is there is no policy test, either in the development plan or in the national policy, for buildings to be the functional minimum for their purposes. Indeed, one only needs to pause for a second to consider how absurd and unworkable that would be on the council's approach, a mandatory requirement to justify the strict necessity of every cubic metre. Many of the finest buildings in the country, many buildings in the local locality, the appeals site, probably the buildings you and I are sitting in right now, would not have been built if they were subject to that requirement. But in any case, it's a bad point on the facts of the case. To quote Mr. McLaughlin again, we began a series of meetings with the client and in particular their Gusar committee. It it was a privilege for me as an architect to have the opportunity to meet this group of dedicated volunteers who look after the dead on behalf of their community. In this modern age where communal relations are often abstract, it was fascinating to listen to them describing their work in detail. And I was taken through the whole process, step by step, and the practical capacity of each space was marked out with groups of people using measuring tapes to understand the movement and placement of a dead body, the people who need to attend upon it at each stage of the process, including Gusar volunteers, close family, and community mourners. The separate strands of visitors, living and dead, were closely mapped out. I found this practical task exceptionally moving. The phrase functional minimum has been used a good deal in the last couple of days. I understand it to mean the reasonable smallest amount of space that's natural for an activity in a place. I confirm we've used our professional judgment to carefully calculate the proper size for each of the spaces involved in the funeral processes. In doing so, we consider the cost of the provision, the carbon impact of the use of space, and the planning framework. All of them pointed towards a reasonable efficiency in planning the building layout. When we design task-orientated working spaces like Gusar rooms, storage, lavatories, the shoe removal cloakroom, etc., we use a combination of physical measurement and industry standard dimensional document books like Neufert or the AJ Metric Handbook. I think you've got a copy, so haven't you, of the relevant part of Neufert. They set out reasonable minimum dimensions from the most indoor tasks, and we've complied with these benchmarks. The prayer hall is a slightly different kind of space in that it has both a practical and a transcendental function. Both are equally legitimate. Neufert proposes 0.85 square meters per member of the congregation for an Islamic prayer hall. This equates to 128 square meters. We then need to add an appropriate space for the dead body to lie, surrounded by principal mourners, and a space to load the body onto the trolley to be taken onto the grave, say 20 square meters each, giving an internal area of 148. Our space is 132.5, which makes it a bit of a squash and a squeeze. The height of the space can be considered in two ways. First, the space needs to be high enough to afford good acoustics for communal prayer. Windows need to be high enough to bring good natural light without glare in a deep space. And the space should be tall enough to ventilate 150 people close together without low-level drafts. Sightlines are also important. Neufert, which you say you've got at ID 10, recommends that for these reasons, auditoria should have elevated room heights. Then there's the sacred and transcendental nature of the space, which should be considered as a material function worthy of consideration. I'll generalize by saying that most Abrahamic religions have, for the past few thousand years, created elevated spaces for the sacred rituals. There is a sacred cultural connection between high illuminated spaces and representation of the divine. President Macron's visit to the newly restored Notre Dame last week would have impressed most of us. But we don't need to go so far or so high. Surrey's full of small chapels with simple elevated roofs that speak for the communal yearnings of its communities through time, seeking a connection with the divine. I think of St Peter and Paul at Albury Park in the Saxon area, St Mary's Church in Farley, and Norman structures, James's in Shear, and St George's Esher from the Tudor period. These are modest buildings, well settled in their surroundings, with elevated roof structures that raise the heart and the spirits. My final benchmark with the new spaces this practice has created for sacred or auditorium buildings and the highly sensitive historic and landscape settings. The Carmelite Oratory, an historic protected structure, is 12.3 cubic meters per worshipper. The Anglican Chapel, beside Lister buildings in Curriston, is 13.1 cubic meters per worshipper. The Faith Museum, which, as you've heard, so is award-winning, a national monument, 6.1 cubic meters per person. The Nazarene Shah Auditorium in the protected part of Worcester College, Oxford, is 6.5. In comparison, this Smiley Prayer Hall is a modest 5.7 cubic meters per worshipper, the lowest of our benchmark samples. Measuring transcendence in cubic meters might be a weird discipline, but it's where this inquiry process has brought us. In summary, I believe that we've used professional care and have been challenged by clients and planning office by the smaller spaces required for the activities that are natural to each place. In other words, a functional minimum. Now, so it's also said by the council that none of the buildings in the vicinity have thatched roofs or barn vernacular. This overlooks the landscape and agricultural history of the area, its policy status countryside, and the sustainability credentials of thatch. And to quote Mr. Rotten again last time in substantive form, A funeral building for the Somali community in the south of England doesn't have an obvious typological precedent. The Trust told me they don't have an Somali style of architecture or any set of visual connotations that we should impose on the building. On the contrary, they asked for a design they felt that would feel, like a natural extension of the landscape around it. They believe they belong to the culture where they live and should use the building forms that reinforce a sense of place, enhancing the setting. We knew that the building would need to contain a hall for congregation and ancillary facilities surrounding it. The building has a direct, practical and spiritual relation to the land around it, as a barn does to a hayfield or a church to a churchyard. We thought of making a simple barn-like form with ancillary elements. Each side might appear like enclosed yards from the outside. The Gusar committee spoke of bodies being washed naturally to return to the earth, and we thought it would be good to make a building that have that same unforced organic unity with the site. We proposed the thatch roof, wood plank wall, and wattle screens. In form, it's similar to the Tudor barns that were once a feature of the area. And given the barn-like simplicity of the structure, we allowed the roof to extend out over the entrance to shelter the arriving mourners getting out of the cars. And that's very similar to the cartways that were a feature of the traditional English barns. We've allocated space under the canopy to unload the coffin and help older and disabled people out of vehicles with dignity without obstructing other arrivals. The space allocation is adequate. The scale is appropriate to allow people to conduct themselves in a ceremonious fashion with dignity in shelter at a difficult moment of transition in their journey and their lives. To justify the use of thatch, wood and wattle, we believe that in light of the climate crisis, it's legitimate to look back to older practices using materials with older, lower embodied carbon than can be sourced close to hand. Mass-produced bricks and clay tiles created in carbon-intensive processes, typical of post-industrial revolution British landscape. I strongly refute Mr. Collett's assertion that thatch is alien. English Heritage and Historical England now publish documents to encourage the revival of thatch construction with its commensurate development of local craft skills. Heritage Britain's website describes thatch as quintessentially English. Our practice consulted carefully with planning officers. It was an exacting process, and the dimensions of the building were thoroughly tested during the pre-app stage. In consultation, we reduced the overall volume of the above-ground structure by 35%, and it was this dramatic reduction in the scale that presented officers to support the proposal. In addition, we conducted community consultations and presentations to local councillors, which I attended personally. We've listened very carefully, and as a result, I believe we have proposed a building and landscape which will be quite beautiful. I work with Oxbridge colleges, faith groups, museum and cultural organisations. I've rarely encountered a client community so invested in long-term quality and sustainable curation of the land they occupy. Now, so in re-examination, Mr. McLaughlin also knocked for 6. The comment put to him that this was his first building with a thatched roof. He said, "The best buildings I've designed are the ones I've done for the first time. For example, our Stirling Prize winner was the first of its kind, an original piece of work by us, which we had to make sure was a success." And he went on to say, in the context of the point about thatch roof, "I have a reputation for working in a very careful way with craft and materials, which are an important part of the architecture, an opportunity rather than a drawback." And whilst, as in any case, there are other types of building which could have been drawn upon, as Mr. Green said a moment ago, Mr. McLaughlin's response was, well, we picked what we thought was the best way, and a key consideration was the building feels natural on the site, with prayerful spaces, good spaces to pray in, a combination of natural materials, light and space. Taking all the considerations into account, we thought this was the best form. I can do no more than, sir, than to invite you to endorse that analysis. And with that, I turn to landscape effects and planning policy considerations. And we make, sir, a number of submissions numbered as below in light of the written and oral evidence before the inquiry. First, as Mr. Collett accepted in cross-examination, the council's reason for refusal is based only upon alleged impact to landscape character and not on the basis of alleged unacceptable visual impacts, the two being separate concepts. Rightly so, views from publicly accessible vantage points outside the site will be limited and at least largely well contained. Such views as do exist, and there will be some, will, for the reasons I've outlined, be of a building of truly exceptional design, a positive rather than a negative in practice, if not in strict Glivia terms, pursuant to which, under Glivia, any new built form introduced into greenfield setting, irrespective of its beauty, is deemed negative. Secondly, the alleged landscape character impact is alleged to be as a result of the proposed building, due to its size and scale, together with ancillary infrastructure, which means, as is clear from the minutes, parking and access. Thirdly, pursuant to Article 35(1)(b) of the DMPO, the reason for refusal is by law the council's clear and precise statement of its full reasons for refusing planning permission. And Mr. Collette agreed in cross-examination that it's right to proceed on the basis that the council intended to comply with this legal obligation when formulating the reason for refusal. That reason for refusal hasn't been amended, and Mr. Collette confirmed that his instructions were to defend, not to expand it, and that the evidence that he produced should be read in that light. Fourthly, it therefore follows that any other points beyond those mentioned above are outside the reasons for refusal and can't be taken to form any part of the council's case. And that includes visual impacts, the appearance of the building, choice of materials, alleged coalescence, proposed use of the building, whether proposed development will be infrastructure within the meaning of policy ICS1, and any alleged impact on the ability to build out the remainder of the extant permission. So I just paused there. There's a rather long footnote at 15 on that last point, which seems to have featured a bit of an afterthought in the council's case. I won't read it out, but draw your attention to it. Fifthly, no harms alleged the settings, either the listed church or the RPG, the Farnham Park. And that's important as the contribution that LCA 6, within which the site is location, plays to the setting of those heritage assets is an important part of that LCA's character as a whole. To the extent the proposed development would be visible from Farnham Park, that visibly doesn't, on the council's own case, harm the experience of the park. That inexorably flows from acceptance no setting harm, because setting is where you experience a heritage asset. Further, no harm is alleged to the AGLV's role as a buffer for the Surrey Hills AONB, and that's an important function of the AGLV generally, as the supporting text of policy RE3 of LPP1 makes clear. Sixthly and fundamentally, Mr. Collette conceded in cross-examination that neither he nor the council contests the principle of a funeral pavilion building on the appeals site, and that puts into fundamental context the council's objection and Mr. Collett's objection to this particular building. Any new building within the Greenfield site would have an inevitable impact on landscape character and indeed an inevitable visual impact, applying the Glivia 3 criteria. Therefore, the principle of such an impact in the council's own case, which doesn't oppose the principle of building, the principle of such an impact can't be a basis for withholding permission. The impacts of the proposed development would need to significantly exceed the inevitable impacts in order for the refusal to be upheld. Seventhly, reflecting this, it's common ground that policies RE1 and RE3 of the Local Plan Part 1 and policies FNP 1 and 10 of the Neighbourhood Plan aren't zero harm or zero change policies. Otherwise, they prohibit all greenfield development, which plainly isn't their aim and would be contrary to the expectations of both other development plan policies and the framework. They have a degree of tolerance for localised, well-contained landscape effects, which don't stray significantly beyond the inevitable impacts of putting a building where there is currently none. The design and development management policies, the DM policies cited in the reason for refusal, are similar. They don't, in the context of this case, impose any more demanding requirements in this respect, as Mr. Collette accepted, nor do they impose a requirement that the design of a new building should rigidly copy what is already in the vicinity, as he also agreed. In the footnote, I draw your attention to the National Design Guide, which says well-designed places don't need to copy their surroundings in every way. It's appropriate to introduce elements that reflect how we live today, to include innovation or change and incorporate new sustainable features. Well, that's what we do. Eighthly, the only expert landscape advice before you is that of Miss Ritson, and Mr. Collette accepted in cross-examination that her evidence follows the Glivia 3 methodology, his doesn't, as the application Glivia 3 falls outside his expertise. And unlike Miss Ritson, he's not undertaken a LVIA or LVA himself, and nor have any of the objectors. He conceded it. Well, he wasn't in a position to gainsay her expert evidence. Ninthly, that uncontested expert evidence was that whilst the baseline character of the site displayed some of the characteristics of LCA 6, its visual qualities and aesthetic and perceptual aspects are affected by detractors both within and beyond the boundaries, for example, the pylons, and the landscape condition is variable. Now, the council's pointed to the extant consent, the further delivery of which would need to be in accordance with its conditions in relation to new planting. But whilst there's some prospect that extant consent will be rolled out, even if the appeal is dismissed, and because there's some prospect it's a material fallback, because the test for fallback is more than merely theoretical prospect of implementation, see the footnote 21. So whilst there's some prospect it will be rolled out even if the appeal is dismissed, there can be no guarantee of this. It would be open to the appellant, if the appeal were dismissed, to dispose of the site, perhaps to a land promoter or a housing developer who fancies their chances of obtaining permission for housing in the context of the new framework and the council's 5-year supply shortfall, noting that the previous dismissal of the housing scheme on the site was a time when Waverley had a 5-year supply and under a different government and different MPPF. Now, as a charity, it would need to consider carefully, very carefully, all of its options in that situation. But in any event, Ms. Ritson has taken into account the extant consent in her analysis. 10th, and fundamentally, as Mr. Collette rightly conceded in cross-examination, the landscape value of the site's contribution to LCA 6, as identified in the Farnham landscape character assessment, would not be harmed by the proposed development. This puts into context the extensive references in the Council's closing submissions to the characteristics of LCA 6 generally and to findings of other inspectors in relation to development proposals on other sites and or for other schemes within LCA 6. What matters, sir, is the effect of this scheme on the contribution of this site to LCA 6, as to which Mr. Collette's concessions in cross-examination were clear. It would cause no harm to this site's contribution to the landscape value of LCA 6. 11thly, the repeated reference by Mr. Collette in evidence, Mr. Green in cross-examination of the appellant's witnesses to openness was misconceived. An error repeated in the council's closings, for example, at paragraph 23. The Farnham landscape character assessment, in fact, identifies the site as enclosed, the very opposite of open in landscape terms. Unlike Greenbelt, there's no policy protection here of openness for its own sake in the sense of unbuilt on land. The relevant development plan policies, as noted above, have a degree of tolerance for the inevitable impacts of building something new on a greenfield site. It's therefore untenable to read across concepts of openness from Greenbelt policy to the present non-Greenbelt context, as the council does. That should say context, apologies. 12thly, sir, for any or all of those reasons, Ms. Ritson's expert analysis that the appeal scheme wouldn't have any significant landscape character impacts and would in several respects provide landscape benefits represents a sound and reliable professional judgment in relation to which there's no contrary expert opinion before you. We invite you to endorse it. And finally, sir, such limited harm as there would be is mitigated in planning terms by the exceptional quality of the proposed development, the fact that the use of the building for funerals is directly associated with the extant use of the majority of the land for burials, and the proposed landscaping scheme described above, which will reintroduce a range of native woodland species on the site, reintroducing elements of the historic landscape. I turn now to highways effects. The key test in this respect is the well-known test at paragraph 116 of the framework. Would there be an unacceptable effect on highway safety, and would the residual cumulative impact be severe, taking into account all reasonable future scenarios? And there's been no suggestion that the development plan imposed any stricter test than policy. Even if it did, it'd be out of date due to the more up-to-date NPPF. The only expert highway evidence before the inquiry is that of Mr. Vett, whose professional judgment is that by a considerable margin there'd be no unacceptable impact on the highway safety network and no residual severe impact on the road network. That's the case, even if one were to ignore the extant consent and assume a zero baseline in terms of trip generation to and from the appeals site. The position is nowhere near marginal. As Mr. Vett explained, the site access junction would operate at only 40% of capacity, the Six Bells junction at only 72%, in an extreme scenario where there's a funeral with 181 attendees. Therefore, even if the traffic were to increase because of projects in central Farnham, as to which objectors offered only speculation rather than any specific evidence of diverted trip numbers, and or if there were even a funeral of more than 181, let's say 200 attendees, the position was still, in highways terms, policy compliant. Mr. Vett's evidence is consistent with and corroborated by the position of the local highway authority, as well as the office report and the committee's decision, none of which object to the proposed development on highways grounds. So putting all of that together, sir, having regard to the above considerations, the proper conclusion is the proposed development is in accordance with the development plan as a whole. As I've already noted, it's common ground that policies RE1 and RE3, the FNP policies and the DM policies are not zero harm or zero change. They have a degree of tolerance for localised, well-contained landscape impacts which don't stray significantly beyond the inevitable impacts of putting a building beyond where there's currently none. The appeal scheme is currently within that tolerance. It will be an exceptionally high quality development, sitting comfortably within its setting and enhancing the local environment. The proposed use is consistent with FNP 10A because the appeal scheme is in accordance with policy ICS1. It is, that should say infrastructure, I don't know why it says I. It is infrastructure as defined by paragraph 83 and footnote 3 of the supporting text. It's a new facility that is required within the meaning of paragraph 4 of policy ICS1, given the unmet need outlined above. The apparent suggestion in paragraph 33 of the council's closing that to be infrastructure for the purposes of policy ICS1 or for the need case to be given meaningful weight, the proposed development needs to be used by a certain proportion, we're not told what proportion, of people from Farnham, is wholly untenable. There's no basis for such an approach in the wording of policy. It's obviously unworkable. For example, if it's right for one kind of infrastructure, it's right for another. So any improvements to the road network would then require assessment of whether the traffic carried on the relevant roads was local or passing through. It's parochial planning at its very worst, which would mean that infrastructure which is needed on a regional level, such as the proposed development which meets a regional need, could never be permitted because its catchment is insufficiently concentrated in one area. In any event, no one suggested, nor could it sensibly be, that if the landscape impacts of the development are acceptable, permission should still be refused on the basis that the proposed use is unacceptable. No one has suggested that there are material considerations indicating that permission should be refused in the event that you find accordance with the plan. If, however, you find the scheme does not accord with the development plan as a whole, then material considerations in that situation do indicate otherwise, so as to justify the grant of permission nonetheless. Notably, Mr. Collette himself, in cross-examination, contemplated the possibility that a near miss of development plan accordance could indeed be outweighed by other material considerations, given the benefits of the scheme. And those benefits include in particular the need for and importance of the proposed development by the Somali community, as I've outlined in section 1. That should be given substantial weight in any event, but all the more so in light of section 149 of the Equalities Act, which gives it a statutory underpinning, for the reasons essentially outlined in the written submissions that you already have on that issue. And I do flag, sir, the footnote 31, the Baker case, which my learned friend relies upon, doesn't actually assist him. It's entirely consistent with our analysis. In Baker, the inspector had treated as an important consideration the disadvantages faced by the gypsy applicants. Therefore, it didn't matter that she hadn't expressly referred to the relevant legislation, the Race Relations Act. She'd given effect to its substance anyway, without referring it to it specifically, precisely because she had treated it as an important consideration. So if anything, that case makes my point for me. It's supportive of our submission that section 149 of the Equalities Act underscores the importance of the Neil Yu case in this appeal. Secondly, there is the exceptionally high quality of the design. We say it amply meets the threshold set in paragraph 139 of the framework for significant weight to be given in a positive sense to good design. And thirdly, the several and important environmental benefits of the development, including the significantly higher than required BNG, the carbon sequestration, and the proposed woodland planting, as well as long-term safeguarding of the site for green use as largely green infrastructure. If the scheme is permitted in its unamended version, the church car park provision would be a benefit, albeit one which the appellant struggles to see how it's sufficiently connected to the development to be required or taken into account. The proposed amendment to the application is within the permissible limits of amendments on appeal, applying the well-known Wheatcroft principles, and therefore you've got discretion to allow either the amended version or the unamended version. I turn now to my conclusions, sir. The proposed development in this case genuinely is exceptional. It would provide the Somali community with a desperately needed consolidated location for the sacred processes of saying goodbye to their loved ones. The building and its setting would be something which not just they, but Farnham too could be proud of. A piece of world-class architecture by a Stirling Prize winner, which it's entirely plausible to think would itself be award-winning, all at truly minimal cost to, and delivering long-term benefits for the landscape with significant sustainability and biodiversity gains, and with the added benefit of safeguarding the site from potential future development pressures which might arise in the event that the appeal were dismissed. Most people go into planning to help make a difference to the built environment for the good of our society. What a chance this proposal is to make a positive difference in the public interest. Wouldn't it be a proud moment to look back on the appeal scheme in years to come and think, I played a part in making this happen? So, sir, for all the above reasons, as amplified in our evidence, we respectfully invite you to allow the appeal, and thank you once again for holding the inquiry in the good humour that you've done.
Thank you, Mr. Banner. Just one point of clarification. It's just one of the footnotes. Just bear with me 1 second. You referred to one of the inquiry documents. I'm just making sure that I've got the right. It's got the right reference.
Yes.
It's to do with Mr. McLaughlin's evidence.
The Neufert document.
Yeah, the Neufert. I think you referred to ID 10, but I think that's the statement of common ground.
Oh,
should it be number 9?
Quite possibly the one with the minarets and it was a single sign, I think, of A4. If it is ID9, I do apologise. It's just the text.
I'll check my inquiry documents and make sure that I have got it. It's been accepted as an inquiry document. If it's not got a reference in there and it was accepted, it will be accepted as IQ as part of IQ9 as a supplementary.
Thank you very much. Thank you.
Okay, that was all from me. Thank you, Mr. Green's still there. The only other point, just in terms of housekeeping, etc., is obviously you may have heard the discussions regarding the deadline.
I did indeed, sir.
Next Friday for revised conditions. So what I'll do after the inquiry is closed is I'll send through a list of the inquiry documents as I see it right now, and any potential queries I have on it, including that Neufert document if I can't locate it. And then obviously then I'll confirm them deadlines for any revised condition submissions and when that should be submitted by, which is 5 p.m. next Friday, a week on Friday. The only other matter to deal with at this particular point, and obviously I noted the conversation we had on day 4, but there have been subsequent discussions, is just the respective positions on costs. I haven't received an application. My assumption was that there isn't going to be an application, but I need to obviously give you both the opportunity at this particular point, should you wish to do so, to make it so confirmation of otherwise.
Confirm the position is as confirmed when we were last together on day 4. So we're not making an application for the reasons that we've explained.
Thank you. Are there any other procedural matters that need to be dealt with before we close?
I'm just going to check the WhatsApp group just to triple check. No one's suggested there are. No, not at this end, sir. So no, thank you very much.
Not from us, sir.
Thank you. Well, in that case, I just thank everyone for their contributions to the discussion and the good humour that we've had through the inquiry. The intention is that obviously I'll await that information that was received by next Friday. Once that's received, I'll proceed to make my decision, provided I have all the information that I need. So on that basis, the time is 4:09 and the inquiry is closed. I thank you all.
Thank you.
Thank you very much, sir.
Thank you, sir.
Yeah.